Good evening, Professor. This is my presentation for the PowerPoint titled, Is an Adoptive Mother Entitled to Maternity Leave? My name is Carla, and for this presentation, I will assume the role of legal counsel for AFSCME Local 10. I will argue that Bainbridge Borough violated the collective bargaining agreement when it denied Carol Fern's request for unpaid maternity leave after she adopted a 3-month-old child. I will not focus on whether this was fair or unfair. I will focus on whether the employer honored the collective bargaining agreement's terms. Let's start with slide number 2 in the presentation. The background of the case is summarized in the facts that Carol Firm has been an employee for Bainbridge Borough for the past 18 years. She is a member of the Local 10 union. She adopted a 3-month-old baby. After doing so, she requested a 6-month unpaid maternity leave. The company denied her request. Therefore, the union filed a grievance. Slide number 3 will pose the big question for this presentation. Did the company violate the collective bargaining agreement when it denied Carol Fern's unpaid maternity leave request? Let's examine the contract terms. According to the collective bargaining agreement contract, the maternity leave will be granted at the request of the employee. It will not exceed 6 months, and as you will see, the specific words are the request will be granted. It shall be granted. There is no limitation as to whether this is only extended to biological mothers. Therefore, we can assume that this request Carol Firm placed should have been granted. Let's move to slide number 5. When we examine the contract and we apply it to the case, we will see that maternity leave is not limited to childbirth only. There is no restrictions on eligibility. It does not exclude adoption. The language is mandatory. Management cannot replace any negotiated benefit. Therefore, Carol met all the requirements for taking the maternity leave that she requested. Let's move to slide number 6. Why is leave important for new mothers? Some people might argue, or some companies might argue, that an adoptive parent does not need to take leave. However, as you will see in this slide, it is important for biological parents to take parental leave because they need to bond with their newborn child. They are the main caregivers of the child, and they need to cope with the family adjustments. The same goes for adoptive parents. They also need to bond with their new adopted babies. They are also the main caregivers for the child, and their family also goes through adjustments, which means that they both have the same requirements. In fact, there are news that although this case is based on a collective bargaining agreement, an example could be used when the Supreme Court in India recognized that adoptive mothers should receive maternity leave regardless of the age of the adopted child. The court emphasized that adoptive mothers should receive protections that are comparable or the same as biological mothers. And this is the law. On slide number 7, you will also see that there are supporting authorities for this stand, such as the FMLA, which recognizes family leave for the following: birth, adoption, or foster placement. Slide number 8. Based on the facts of the case and the language in the bargaining agreement the company had previously signed with Union Local 10, I believe that the remedy for Carol should be that she should get her request for 6 months of leave granted, that the company should honor the bargaining agreement, and that the grievance of this case be sustained. In conclusion, because the collective bargaining agreement states that maternity leave shall be granted and contains no exclusion for adoptive parents, the borough violated the collective bargaining agreement when it denied Carol Fern's request. And you will see all the references that were considered in this presentation in slide number 10.